Welcome back, everyone, for our third and final day of debates for MSP 200 Common Ethics. We are zoning in for our ethical debates. Today, our first debate is the main topic of libel in the plaintiff's case. On the right side of me, I have Melissa and Sabrina here on the pro/for. All right. On the left side of me here, I have Patrick and Sean on the con against side. Their main arguments are going to focus on the ease to promote emotional distress, sensationalism, and public figures. So we're going to start with our pro team. You'll have 6 minutes, all right, on my timer, and you'll have the topics and the arguments. So you're on the clock starting now.
Imagine a public official is caught using drugs in a public place. Wouldn't it be the public who relies on this official properly to represent them, want to be informed? It is important we hold our officials and figures to a higher standard since they hold stronger influence than private citizens. Now imagine you are a private citizen who has a strong relationship with your mother. Someone sees you giving your mother an embrace and then goes on social media with a picture of you hugging your mother and makes a claim you are in a sexual relationship with her. Wouldn't this cause emotional distress and harm to your reputation? The statement made was false, yet you feel immense shame and are unable to live a full life. This is why we have libel law. According to Ross, libel law is meant to protect an individual's reputation. In order for a private citizen to prove a statement is made with libel, they must be able to prove that the statement was in fact false, the publication distributed the information to a third person, the faulting amounted to at least negligence, and damages or emotional distress was caused. Emotional distress is defined as emotional harm. We are claiming that the laws are correct as they stand, yet may need some adjustments. Being in the case of emotional distress, it can be extremely difficult to prove that something horrible is happening inside of you because of a false statement. Needing a doctor or a psych expert shouldn't be the basis on proving your life has been majorly damaged. The laws as they stand, on proving your life has been majorly damaged. The laws are correct but should be adjusted to incorporate other forms of proof for emotional distress. We are also claiming that the laws regarding sensationalism of public figures are correct as they stand, that news outlets are entitled to provide information about public figures and officials about their conduct as long as it's considered public knowledge, or occurs in a public place, or isn't considered actual malice, which is described as a defined knowledge of falsity or reckless disregard for the truth. Public officials and figures have long since earned notoriety through their influence on our government and voluntary appearances in the media. It is our First and Fourth Amendment rights to criticize their behavior and work as society holds them to a higher standard. While that does not mean publishing highly offensive materials such as mental illness conditions, health records, personal financial records, etc., it does allow free rein for any information provided to the public, including public government records, or anything said or done. Actual malice must be proved of public figures in libel cases in order to differentiate what is considered newsworthy and what is considered reckless disregard for the truth. It is when the information being published falls under that category of actual malice, highly offensive, does it infringe on the invasion of privacy torts. In the case of Alex Jones versus Sandy Hook, Jones claimed the shootings were part of a government conspiracy to confiscate Americans' firearms and that the victims' families were actors in the scheme. In this specific case, the false information that was being broadcasted was extremely harmful to the families who lost their children and loved ones. The spreading of false information was considered libelous, and Alex Jones lost the case. According to Justice Warren at the Curtis Publishing v. Bus and Association case, differentiation between public figures and public officials and adoptions of separate standards of proof for each has no basis in law, logic, or the First Amendment policy. Meaning for those who work for the government, or for example celebrities who influence the lives of public citizens, should both be held to the same standards in libel cases. Magazines like The Inquirer have long been criticized for publishing material about public figures that seemingly may cross the line. In fact, the information being published is considered public knowledge. Whatever a public figure does in public spaces is considered free rein for media outlets to publish and write stories about. Libel laws are put in place not only to protect the freedoms of the media, but also create a standard to protect not only public citizens, but private citizens from harm. We should be allowed to criticize and discuss individuals who choose to make a living by being in the public sphere without consequences. It is our responsibility to allow media outlets to deliver us information to the best of their abilities, unless inciting harm, invading our privacy, or causing emotional distress.
The Cornell Law Library defines emotional distress as a mental suffering as an emotional response to an experience that arises arises from the effect or memory of a particular event, occurrence, pattern of events, or conditions. In a libel case, there are two examples of emotional distress: intentional infliction of emotional distress and negligent infliction of emotional distress. Intentional emotional distress is with the intentional meaning that the defendant knowingly inflicted the distress, and the negligent infliction of emotional distress is unknowingly. Regardless of the emotional distress inflicted, the plaintiff deserves the same recognition for the suffering inflicted. Negligent infliction of emotional distress requires the proof that the defendant had a duty to use extreme care and that the defendant negligently breached that duty. To further understand the depths of this and the complexity in proving emotional distress, we can take a look at the case of Donegan versus Elliott. In the case, Donegan created a private list of men in the entertainment industry. The list held the understanding that every man listed was being accused of sexual misconduct. The private list was eventually released to the public, openly listing and accusing over 30 men of sexual misconduct. Elliott in particular went on to sue for emotional distress damages, claiming the list had ruined his life, causing extreme depression and even the contemplation of suicide. However, despite the horrible effects the list had on Elliott, the case of emotional distress was eventually dismissed because it could not prove malicious intent. Elliott was obviously struggling mentally and suffered severe effects from this list, and his case was completely dismissed. The creation of the list itself should have been enough of a malicious intent to prove Elliott's emotional distress. Proving emotional distress is so difficult because the suffering is often happening internally. The judge and jury cannot see the pain that has been harmed by the defendant to the plaintiff, making it more difficult to comprehend the depths of their suffering. It can be inferred if someone's life is destroyed by defamation that they are probably not in the best mental state. Yet we still make these victims of defamation prove that they have been harmed, further agonizing the distress they've already suffered. I believe if the person's name and reputation is harmed, regardless of the intent of the work published, they should immediately win emotional distress cases, especially if they've already had won the libel case. Forcing a victim...
That's time, group one. So now our con team has 3 minutes to ask any clarifying questions, and you're on the clock starting now.
So my first clarifying question is, what would you say is the line where you would deem something to be emotional distress?
Well, I look at it as if your mental health was harmed from something that was published and your name was completely slandered in the media. Your mental health at all. I feel like if it directly had a effect on your mental health, it should be considered emotional distress. Especially if you win a libel case, you already proved that they either maliciously defamed your name or negligently defamed your name. If your name was defamed, especially in our society, we know if something is published, it's on the internet forever. Your name will be out there forever slandered. And I feel like you cannot not say that will affect your life for the rest of it. And I can attest that I feel like it will have a really big mental effect on you for the rest of your life.
Yeah. And I'm sorry, just to add on that, I would think that also including social anxiety, not wanting to get out of the house at that point, anxiety in general, and the onset of depression would be reasons to be.
How would you prove something like that?
See, I feel like if it was really the defendant himself could express these emotions. I mean, you already saw that their name was publicly slandered, and I feel like it could just honestly be inferred that if your name was publicly slandered to the billions of people in the world, that you would feel some type of emotional distress, basically. But if there was proof needed, you could eventually bring in a psychiatrist, but I just don't feel like it would be needed for every single case, especially depending on the type of slander or defamation that was caused by the libel case.
Would you feel that it is necessary to have set parameters as to which emotional distress can be defined as?
I think it could be, but I mean, going back to mental health, your mental health could be different from somebody else's. So say, like Melissa said, social anxiety or depression, it should not be limited to one sort of mental illness that you get from what happened to you. I just feel like you can't put a cap on it because you don't know how someone could react to their name being publicly slandered, and I feel like every person will have a different differentiation of emotional distress depending on what was said about them in the media and published.
All right. Now we have 6 minutes for the con team to present their arguments and introduction, and you're on the clock starting now.
Okay. So spreading false information about a person is not only unethical, but is grounds for lawsuit in some circumstances. Those who spread these lies may be acting in bad faith in order to ruin a person's life. This is known as intentional infliction of emotional distress. Currently, there are laws in place that allow for the victims of emotional distress to get recompense. These laws are in such a way as to allow for everyone from the most well-known celebrities to the most recluse individual to get justice. The laws are so worded in such a way as to protect individuals from being falsely accused of libel and intentional infliction of emotional distress. The current libel laws with respect to intentional infliction of emotional distress are proper as they allow for sufficient protection from the prosecution and defense, and because they grant no special privileges and preferential treatment for public figures. Some key terminology for this would be intentional infliction of emotional distress is defined as emotional distress occurred when one acts abominably or outrageously with intent to cause another to suffer severe emotional distress, such as issuing a threat of future harm. In other words, this is when a person acts in a way that intentionally causes severe emotional harm on another. For the purposes of this argument, the emotional distress being discussed is a result of libel. Legal Information Institute defines libel as a method of defamation expressed by print, writing, pictures, signs, effigies, or any communication embodied in physical form that is injurious on a person's reputation. The current libel laws with respect to intentional infliction of emotional distress need not amending, with cases which are a term. Let me restart that sentence because. Yes. With cases where a term is subjective and personal, creating a strict parameter in which to prove that said term is near impossible. For this argument, it is near impossible to exactly pin down what exactly constitutes emotional distress. Keeping with the interpretation of what emotional distress is allows not only for defendants being wrongfully accused, but the protection of the First Amendment. A clear example of this is Hustler Magazine v. Falwell. In this case, Hustler Magazine, a well-known parody magazine, published a story about Jerry Falwell being an incestuous drunkard. Falwell tried to sue Hustler Magazine for intentional infliction of emotional distress and libel, and the Supreme Court ruled in favor of Hustler Magazine, ruled in favor of Hustler Magazine and rejected Falwell's lawsuit due to his status as a public figure. Justice Rehnquist, who was the Chief Justice, wrote in the opinion, at the heart of the First Amendment is the recognition of the fundamental importance of the free flow of ideas and opinions on matters of public interest and concern. In this case, Hustler Magazine was being wrongfully accused of inflicting emotional distress, and the vague terminology, along with the First Amendment, which is so vital to the United States, has made Hustler Magazine win that suit.
And then building off of that, as a private figure, you must prove negligence to prove a libel suit. And then as a public figure, you must prove actual malice to win a libel suit. And while it's a common understanding that proving actual malice is more difficult than negligence, there's a reason for the supposed double standard. Basically, public figures, they're equally protected by the law and any other private figure. If they weren't, they wouldn't even do their jobs. It would pretty much be too much of a hot zone for them. As a public figure, you're assuming the risks of public acclaim, but that risk comes with the advantage of a generally greater advantage of resources and access to information as a private figure. That extra layer of having to prove actual malice isn't as hard as you would expect with the advantages of being a public figure. A JDJ Journal, which is a law-focused news journal, they posted an article of 10 celebrities who all won big in lawsuits, defamation lawsuits. And the list records celebrities like Robin Williams, Tom Cruise, J.K. Rowling, all of which were affiliated with defamation suits, and they won the case. And the other reason for this double standard is for the sake of the press. The press, they're kind of like a check and balance to our system and our government, and they should have the right to be able to, constantly be questioning public figures and reporting on them. And if they were punished, if the press was punished every time there'd be something controversial was reported, and then there would be no press. I mean, honestly, every society every society ran by something like a tyranny has this pattern of press suppression. So, and it's a pattern throughout history too. The press should just largely be able to constantly say whatever they want whenever they want, and yeah.
All right, now we have the pro team. You have 3 minutes to ask any clarifying questions to the con team, and you're on the clock starting now.
Why do you feel it's nearly impossible to prove emotional distress?
Because, as you have stated in your argument, that it is a subjective thing. It is a personal. A person's mental health well-being is a personal thing to them. So it is nearly impossible to write down in exact words what a person would need to feel in order to constitute emotional distress.
Have you ever experienced emotional distress in anything that you've ever done? Have you ever felt harm from social media, or someone incited harm, or was talking smack?
Specifically on social media?
So this will be a personal question,
Okay.
so you have to, if you're comfortable answering
I
that,
don't.
you
Yeah,
may.
I don't care.
Okay, that's fine.
What? Say it one more time.
Have you ever specifically yourself, any of you, felt that you were being attacked, or in person or on social media? Well, let's say in social media, because we're talking about the media here. How did you feel after that?
Well, not good. This was honestly, to be honest, any sort of like real emotional distress. It was more so when I was a lot younger and more like naive to social media and everything like that. So yeah, I felt bad about it. It was mostly. Yeah, I mean, I felt bad. It wasn't. What are you getting at? I mean,
Essentially, what I'm trying to say is, was it difficult for you to express to others how you were feeling at that time? Was it difficult for you to come out of your house? Was it difficult for you to go to school?
no.
Was it difficult for you to behave?
Well, for me
normally?
specifically, no. But I could agree that other people might have a harder time coming out from that. Where I could agree with you on that.
Okay.
Do you think that claiming that you can't claim emotional stress kind of diminishes the mental health crisis we have in America today?
Sorry, just one more time.
Yeah, say that.
Do you think that saying that you cannot claim emotional stress kind of diminishes the whole mental health crisis that America is suffering with today?
I'm not claiming that you can't claim emotional distress. What I'm saying is that it is near impossible to pinpoint down exactly how to define that. This is not to say that you cannot win an emotional distress case. In fact, that it should. My thought process is that the laws that are currently on the books make it easier for you to prove emotional distress, rather than if you try to change the law in order to write down specific parameters for that.
Well, I don't think personally. I think my argument was
So only the questions
Right,
on
sorry.
this end, but it looks like we're running out of time there for only 5 seconds left. So let's go ahead and move on to our rebuttal and counter arguments. The Pro 4 team will start. You'll each have 3 minutes to provide your counter argument. Remember, there are no new arguments presented during this time. So you are on the clock, Pro team, starting now.
As American citizens, it is our right to freedom of the press. That includes the occasional false statement being made about public figures. We should not demonize journalists for printing incorrect information. Everyone is human and makes mistakes. Keeping a high standard of proving actual malice is what separates the U.S. from fascist countries. Americans should be allowed to criticize and print information regarding public figures, no matter how ludicrous it may seem. There are already codes every journalist must follow and print accurately as humanly possible. Restricting these rights would restrict Americans to receive the best and important news that we deserve, and that's about sensationalism. Go ahead.
So my argument is that saying that the defamation of a person and the ruining of their reputation is enough to win an emotional distress case is not plausible, because it will be abused Regardless of who the person is, what slandered their name, and what was used to slander their name, no one should be able to publicly dictate another person's life with a lack of proof. By allowing the emotional distress cases to be won without the presentation of malice or negligence, we're legitimizing the valid feelings of the plaintiff. The theory lies in the fact that if your name is publicly slandered, your life will be hindered, and that it will always take a toll on you mentally. Not everyone should be immediately compensated or even compensated at all. That should lie with the depth of the defamation published, but the plaintiff should be given the validation of the extent of the damage that the defamation does to a person. That's what we have.
All right. Now we have 3 minutes for our con team. You're on the clock starting now.
Those who argue that it should be easy for the prosecution to prove emotional distress do not take into account the ramifications of the effects that would have on the First Amendment. Ultimately, the reason why it should be difficult to prove that there was intentional infliction of emotional distress is because it can be easily used to silence speech that some may deem as offensive. The First Amendment was put into place as the most important right in the Bill of Rights because it is necessary for freedom. In the United States, people have the freedom to offend and critique other individuals. When this ability is stripped away, it gives carte blanche for authoritarians to deem all speech that goes against their narratives as causing emotional distress. In the micro timeline, it may seem that it is compassionate to allow for people to sue for emotional distress and to easily prove that. However, these advocates may even have good intentions. However, the road to hell is paved with good intentions. Those who are acting in bad faith can easily use the threat of lawsuits to cancel dissenting voices, and that's specifically with the press.
Yeah, and what he means by the road to hell is paved with good intentions. It's so easy for someone to just it's so easy for someone to just fake having emotional distress. If we just started handing out like emotional distress cards, people would just be using them to their advantage all the time to get as many things as they wanted, or whatever they wanted. So, yeah, and the libel laws, I mean, they're exactly how they should be. They have the ability to be stretched one way or another, and that has fair judgment on an individual's distress, because if you're able to stretch how emotional distress is defined, you're able to really pinpoint if it actually is applicable to that person. And yeah, that's pretty much.
All right, now we are at the end where each team or debate team will have the opportunity to present their concluding kind of thoughts here and why they felt their argument was the best. We're going to start with the pro team. You have 3 minutes and you're on the clock starting now.
So we have accurately described in depth the sensationalism of public figures and making it easier to prove emotional distress. We explained how the treatment of public figures in terms of the libel case are justified as they are chosen to be either public or officials. As someone with so much power with our society, is key that true information is spread to our society. We cannot lie and say that sometimes this law can be abused, but as Americans, we have the right to free press, the good, the bad, and the ugly truths. We have also proved the unjust laws regarding emotional distress and the brutality many plaintiffs face throughout libel and emotional distress cases. Mental health is severely overlooked in our country, and the strictness of emotional distress laws is an example. If a libel case is one, it has to be proved that the information provided is false, and the plaintiffs are left to deal with the intense and life-altering repercussions that have come from these false claims. Having to make them prove negligence or malice is ludicrous. Obviously, due harm was done, and there should be no need to further extend the depths of the damage. Throughout our arguments, we have spoken with passion and urgency about these two topics. Public figures and officials make up our entire society and in some ways represent everyone in our societies. It is crucial that they are held to a higher standard because of the responsibility they have as our leaders and representatives. So what if one day crucial information about them just started to disappear from our media? Unfortunately, as public figures, the Ugly parts of their lives can often be considered newsworthy. We do believe that some news is published with malicious intents, and it cannot be denied that there are often ulterior motives behind what is being published. However, as a public figure, your job is to be scrutinized and talked about, regardless of the information posted. And as a country who prides themselves on our freedom, the press is one we cannot take for granted. In regards to our arguments, personally, I have come in contact with what could potentially be a libel and emotional distress case from a friend of mine at another college in a fraternity. Recently, an Instagram was created accusing many men of different fraternities of sexual misconduct. However, the Instagram listed no specific names, only the fraternities as a whole. While I'm sympathetic to these women who have come forward with their stories, this Instagram account has now slandered and defamed over hundreds of people who are associated with these fraternities. And the accusations have been extremely damaging to their names and reputations. My friend, for example, who took pride in his fraternity, believes most of these claims are false, and as he does not live on campus, so could never be accused personally, is livid. He joined his fraternity to make real-world connections, and now his name is being slandered for simply his association. The emotional toll it has taken on my friend is horrifying, and something so horrible as sexual assault is now linked to him. So what if he did take this case to court as a libel case, proved the accusations false, but lost the case of emotional stress because he could not prove the page was negligent? Was his own personal mental health not enough proof, or the fact that his name was publicly slandered to hundreds of people? I don't know about you, but it seems more than likely to prove he was affected emotionally. Of course, this would not be true for every emotional distress case, like a physical injury emotional distress case, for example, but in the instance of emotional distress cases brought on through a libel case, this seems entirely more just.
All right, so now our con team is on the clock. You have 3 minutes to state why you felt your argument was the best, and you're on the clock starting now.
The law is there to regulate our actions and provide justice to each and every action taken. That's what the law is. Our behavior of action is pretty much unpredictable. There's no definitive answer to why we take certain actions, especially how we perceive the actions that we take, and others around them. But the law is the only system in place that is able to regulate those unpredictable actions and behaviors, and they do that by allowing there to be more than one form of regulation to a certain problem. Just like the so-called vagueness behind libel laws. Or just raising a bar for public figures' defense in a libel suit. They're just examples of the government pretty much learning from its past mistakes and making them new, is how I see it. And this kind of different standard exists because public figures are at the center of matters of public concern, and reporting on them is sort of like a watchdog role on our part.
Ultimately, this boils down to a First Amendment argument, because the reason why I became passionate with this is the fact that a political commentator, Jerry Falwell, he tried to sue a magazine because they made fun of him. And if he was able to easily prove that magazine publication was cause of distress, and he was able to shut down that magazine, who is to stop any other politician from doing that as well? So this ultimately comes down to whether or not the First Amendment should be upheld when it comes to public figures being ridiculed by parody magazines or justly critiqued by journalists. It all comes down to if we have freedom of the press, because, and I forget the exact quote, but somebody once said that the press is like the fourth branch of government. They check the rest of the 3 branches. So if you take away that fourth branch, then everything else crumbles with it. Therefore, is that the timer for the end? Oh, sorry.
15 seconds.
Oh, that is all I have to say about that.
I'm in.
All right, everybody, let's give it up for both teams one time now. Whoop, 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 whoop. Now we enter our question and answer session from the audience. All right, come on up, Ethan. We'll start our timer here. We have 15 minutes.
I guess I'll start off with you guys. So, Should we be punished for spreading false information if we believe it is real? Or is getting things wrong necessary to allow us to question things before we can verify them?
Do you, or go ahead.
To your first point, no, you should not. If you believe it to be real, no, you should not be punished by that. With a little caveat to that, though, once you have been proven false, you need to say so and make it public that what you have just said was slanders, was a lie, and you need to come 100% clean. And I think, yes. And what was the second part of that you mentioned?
Is getting things wrong
sometimes,
is that necessary to allow us to question things? Or is it possible to verify these things before most of the time, do you think?
You should try your
Well, you can try your best to verify it, but I'd say most of our like rules and regulations are from mistakes almost 99% of the time, so yes.
The Constitution, although it's a great document, it has multiple amendments because we got certain things wrong. So yes, in order to find the truth, you need to first say everything and then whittle down what is correct and true.
All right, thank you guys. So for you guys, how do we discuss government conspiracies if we are penalized for getting details wrong? So, for example, the government at one point injected syphilis into black men to study it while telling the people they were receiving a government treatment. So like, for like a modern day example, if someone suggested that the creator of the COVID vaccine was causing something like that, could that be considered defamation with malice or emotional distress? And what would be like the standards for if it is or wouldn't be?
I think later on when it was proved of the malicious context that it was done in, then yes, I think that they could have absolutely been sued for defamation and libel because it was done with actual malice. But I think that yes, there are going to be conspiracy theorists that should be allowed to say what it is that they want to say. But if what they're saying is causing actual harm, like in the Alex Jones Sandy Hook, and I know I prefaced that already, but I'll preface it again, where it caused extreme harm to the families that were affected, then yes, I do feel like that should be a defamation case.
So like in reference to that one?
Sure.
So it's like Sandy Hook, like there's numerous parents who you can verify with their parent that the kids unfortunately were part of the tragedy. So in that case, then since there's proof that Sandy Hook exists, like that would be the reason that, like, because you can prove that Sandy Hook happened by talking to people involved, where what if like if you couldn't do it, then it wouldn't be defamation if you couldn't prove it, but since Sandy Hook was provable, then that's where you put the law.
I think as if say the parent wanted to sue, if it was not, I think they have the right to sue regardless if it was proved or not, because they are, I mean, even if it's proved untrue, I feel like they are still, as the parent of that child, suffering that emotional distress from what they are putting out there, regardless. I don't know, it's a tricky question.
Yeah, I think it is tricky, but I do agree. I feel like regardless, they should be able to sue, and yes, because it is something that is provable, absolutely.
So like, had he been right then, you would say it wouldn't be defamation if he had been correct in saying that?
I would say yes.
Or if, like, if there was not a way to verify so that Sandy Hook happened, then it would be not defamation?
Correct.
Okay, thank you.
Yeah.
Guys. Great answers. Great job.
Thanks.
Thank you.
Anyone else in the audience have questions? Keith, come on up.
Keep going. That was hard. I didn't know what to say.
All right, so I have a question for you guys.
Okay.
So in order for a public figure to win a libel case, the public figure had to prove that the publisher of the false statement acted with actual malice.
Correct.
Yes.
How do you prove that?
Well,
I have it written. Defendant knew the statement was false or subjectively entertained serious doubt that the statement was truthful. So you have to prove that that statement made was completely untrue, you know, about that person. Like I said, you know, like in the defamation case of a public figure, like, or even, I know I said with a private figure for this, but like, yeah, I think there was, I forget the specific case, but I think it was like the Inquirer, not Inquirer, but the one magazine where it was talking about like the guy having a relationship with his mother, like
right,
the I forget that exact one, but you know. Esquire magazine was was stating that the politician was having a sexual relationship with his mother. Like, that's clearly not true. And I think that it was obviously the writer, the journalist knew at that time that it was an untrue statement, that they just had a close relationship. So therefore, you could prove actual malice because it was something that they genuinely knew was untrue and still printed about.
Right. And I mean, there's no reason to print that other than to ruin their reputation and create false information about them. So that in itself is enough of a malicious intent.
Okay, second question for posting. So if journalists could get punished for like every error they publish, don't you think journalists going to like step back from controversial issues and we the public going to suffer because we're not going to have access to information?
Well, no, because as a journalist, it's your job to research, to study, and to really have a deep understanding of what you're going to be publishing. Like, it is literally your job to have facts in what you're publishing. So if it's like you're kind of not doing your job if you're publishing false information.
And I was also going to just say, I'm sorry to interrupt
Yeah,
you, was like, our argument isn't saying let's punish them for making, like,
No.
people are going to make mistakes, and that's okay.
Yeah, and those mistakes can cause emotional stress.
They can, yes.
They can.
Yes.
I mean, if that does happen, then the plaintiff has the right to sue if it does cause emotional distress.
Yeah, so my question, I understand what you're saying. So my
Okay.
question is, we are humans and humans make mistakes.
Right.
So, do you guys like put any standard like there should be like to a point that we should let this slide because it happened like it was a little mistake or something?
Well, I guess that really is up to the plaintiff. I mean, you could take it as a libel case and sue for defamation, or you can choose not to sue for emotional distress. That really comes down to the plaintiff himself and what was published about them.
I totally agree.
Now, to your point where you said that wouldn't that scare away journalists from approaching topics like that, that's kind of the point that I made within my argument, that if journalists are constantly walking on eggshells if they're like, oh, if I go into this touchy subject, am I going to bring a lawsuit onto me because I went into those subjects, it's going to shy a lot of people away from going into journalism, because the media and journalism at large isn't like a monolith. It's made up of individuals. And you as an individual, would you ever go into a line of work where you're like, oh, there's a very real possibility that if I delve into a certain thing, if I ask the wrong questions, that I can be sued, I can lose my job and lose everything? No. So you need to have these protections for the journalist. And
Yeah, and I agree with everything he's saying, but like to an even more extreme note, like if you look at someone just like I think in like 2018 there was some like protest for journalism suppression in Myanmar. There's some, it's not really important, but there's like basically some sort of refugee issue, and there was some human rights violation that happened, and 2 journalists went and tried to report on it, and they were both arrested, and there was a humongous like protest, and it even sparked other countries around them, journalists around them in other countries to protest as well. So and I think and like
I just want to, libel in itself, to win a libel case, you have to prove that what was written was wrong. Like, you can't bring a libel case about because you don't like that something was wrote about you, especially if it was true. So I feel like that's kind of not, like, as a journalist, your job is just to report the truth, regardless of it's, like I said, the good, the bad, or the ugly. Like, so as a public figure, you're going to be exposed to that. And you can't really bring a libel case onto a journalist if what they're writing about is true or publishing is true. So I feel like it's kind of difficult in that sense, because as a journalist, if you're a good journalist and what you're writing and publishing is true information, then there should be no concern that you'll ever have a libel case against you in the first place.
Thank you.
Thanks.
Oriana, do you have a question, or anyone else that didn't get a chance? No.
I was just watching in the other room. I wasn't here for most of the time. You guys did really well. But it's kind of just a clarification question for both sides. So, in the cases for a journalist to be talking about something, is there like a certain leeway that's given for a private person instead of a public figure?
Or what do you mean by
It's-
leeway?
there's-
Like, if someone was to say something about if if a private figure and a public figure would do the same thing, and then a public figure felt some type of way about it,
Yeah.
and a private figure felt the same way about it. Is there like a leeway that would lead for the case to lean more towards the public figure?
Yeah.
Get the winnings
Like
in that
I
case?
said before, that there's like if you're a public figure, you have to prove actual malice, which is like
So, like that.
inflict like the person who committed they have to you have to prove that they actually did it intentionally to harm you and cause emotional distress purposely, versus if you're a private figure, just like a common person, you have to prove negligence, which is just being negligent to someone else's emotional distress. So yeah, there is a little bit of leeway, but it's on purpose.
Yeah, there's a four-pronged test for a private citizen versus needing to prove actual malice for a public citizen. So that would be like, in fact, the statement was false. The public distributed the information to a third person. There was falsity and emotional distress. So, and then just actual malice for a public figure, since they put themselves into that situation all the time. Let me reword that. Since they put themselves into the public eye and they're open for scrutiny.
Okay, that makes sense. Thank you. That's the only thing that I would clarify.
Thanks,
Thank you, guys.
Drello.
All right, everyone. That's all the time we have for this debate today. Let's give it up one time for both teams. We'll be back with our next and final debate on the First Amendment and free speech. Thank you, everyone.